We still have a fairly significant gaps in our legislation when it comes to core international crimes.
No one can act with impunity.
These are crimes that are beyond the pale.
We are talking about human beings. We're not talking about numbers.
We need a court. That's as simple as that.
This is Asymmetrical Haircuts, your international justice podcast with Janet Anderson and Stephanie van den Berg. This episode was produced in partnership with justiceinfo.net.
All rise.
Hi everyone, this is Janet here. I'm really sorry, but there's no Steph. She's down with the flu, so it's just me. If she had been here, we might have spent a bit more time trying to find out what she actually knows from behind the scenes at the International Criminal Court as they batten down the hatches in expectation of the Trump presidency, which is about to take over. Why? Well, because this just happened.
H.R. 23, a bill to impose sanctions with respect to the International Criminal Court, engaged in any effort to investigate, arrest, detain, or prosecute any protected person of the United States and its allies.
Yep, that's the vote in the House of Representatives of the United States of America for sanctions on the International Criminal Court for pursuing any investigations into the United States or its allies who are not members of the court. And, of course, it's really designed to protect Israel. Because, as you know, Karim Khan's office at the International Criminal Court pursued arrest warrants against senior Hamas officials post the major attack on Israel on October 7th. That's all a little bit moot because at least 2 of the 3 people there are confirmed dead and the 3rd one is likely so. But he also went for arrest warrants on Israel's Prime Minister Benjamin Netanyahu and the Minister of Defense Yoav Gallant for specifically the crime of starvation, because of the blockades on the sufficient aid getting into Gaza during Israel's massive response. So I'm actually writing a piece at the moment on US sanctions for Justice Info, so I'm not going to say too much here, but I will say what I've found out is that sanctions are tricky and there's still a lot that we don't know. And what stands out quite starkly is the hypocrisy of the United States' move against the International Criminal Court when there's really bipartisan support for the court on other things like Ukraine. So let's now move on to today's main part of the show, which we'd also planned as President Trump is moving into the White House, because we've been wondering what might happen on the bigger picture on how the United States is pursuing universal jurisdiction. We've always seen quite a lot of activity in the US and been covering it at different times. But as an outside observer, I've certainly been struck by the numbers of civil cases that have gone on rather than criminal cases, and that there seem to be some kind of big gaps where some specific crimes could get accountability and others couldn't. And if you look back, it was just a couple of years ago in 2022, after Zelensky, Ukraine's president, addressed Congress, then a bill was passed which strengthened the War Crimes Act. And that's an act that was strengthened to allow the United States to put on trial anybody in their territory suspected of war crimes, even if the crime was overseas and even if the victim was not American. Because under a previous version of that law, the authorities in the US could only prosecute war crimes if the alleged perpetrator or victim was a US national, which would have meant that if a Russian soldier who committed war crimes against Ukrainian nationals came to the United States, they would have been able to escape criminal prosecution for their crimes abroad. And kind of to explore all of what has been changing and how NGOs have been making use of those changes, I contacted Carmen Cheung, who's the executive director of the Centre for Justice and Accountability. And she's been on our list for far too long to come onto the podcast, and I'm really happy that she could fit us in. I was speaking to her last year, just around the US elections in October, and obviously before the latest news has come out of Syria, which may well affect some of the Syria cases that she and I spoke about. And she was explaining to me that even though, of course, there is this new war crimes legislation, there are still big gaps. Like the United States has still not enacted any sort of statute related to crimes against humanity, even though that's something that civil society in the US has been working on for decades.
the fact that we did not have present in jurisdiction for grave breaches of the Geneva Conventions did create a loophole and a gap in coverage. And so the 2022 amendment does do that. However, it doesn't do everything that we needed to do. It might bring us in line with Geneva, but it doesn't bring us in line with contemporary international criminal law and how we think of universal jurisdiction and how core international crimes should be prosecuted at the domestic national level.
Yeah, and she described how the whole situation across the US on accountability and the options that are available is a bit of a patchwork.
Prior to the 2022 amendment to the War Crimes Act, we still had federal statutes that allowed for present in jurisdiction over certain offenses, such as torture. And so I think what the United States had up to that point was a patchwork of legislation, some of which provided for a present in jurisdiction, some of which didn't. And we still have fairly significant gaps in our legislation when it comes to core international crimes.
So here we go with the whole interview with Carmen. And of course, I send my best wishes out to Steph and hope that she's back with me in the saddle next week. For this interview, though, I started by asking Carmen why she thinks it's important to actually have universal jurisdiction cases.
There are a number of different reasons why I think universal jurisdiction is important. I think for the United States in particular, it has for far too long relied on immigration law and administrative offenses to address core international crimes. That's problematic for a number of reasons. The first is that it really doesn't name the crime for what it is, right? When you prosecute someone for an immigration offense or you simply deport them for violating our immigration laws, you don't address that fundamental core international crime. You don't address the fact that this person has committed torture, has committed genocide, has committed a crime against humanity. So I think that's the first thing. The second thing that I think is problematic about using administrative law to address core international crimes and human rights violations is that it does violence to our domestic law. Providing a 30-something year sentence for violating immigration law is problematic in the context of, in a country like the United States, where we far too often use our immigration law to criminalize immigrants. And I think that as universal jurisdiction practitioners, we need to think about the impact of how we use domestic laws in advancing international justice aims and the impacts of that on domestic human rights systems.
You sound quite self-critical there. I mean, I've always associated CJA with some of those attempts to say, look, this is the only way that basically we can get this person, so let's go for it. I mean, to what extent do you look back and say, it would have been better if?
What I will say is that CJA hasn't done one of those cases for a very long time. And I think part of that is based on that self-reflection of what is our role as a U.S. human rights organization and as an organization that has a role in addressing international human rights violations, certainly, but also has a role and responsibility as a human rights organization based in the United States to ensure that our rule of law is robust, that our courts respect human rights, and that we are operating in a system of law that is fundamentally protective of human rights. And so we have been thinking quite critically about the role of immigration law when it comes to addressing core international crimes. And that has definitely shaped our practice over the last several years.
And this particular new development, I mean, it's already more than a year old. When I first read about it, I thought, okay, well, that's basically just for Ukrainians. But in fact, it could be taken more widely and it could help victims of war crimes in other countries. And if that's the case, then where are we going to see the first cases, do you think?
Yeah, absolutely. I mean, I think what I will say about the Ukrainian situation is that the United States did actually bring charges against Russian soldiers for the killing of a U.S. national. Now, as you noted, that was available under the previous legislation, and so it didn't need an amendment to the War Crimes Act in order for that to happen. What I do think is interesting about that case is that the U.S. brought that case against individuals that they didn't have in their jurisdiction. I think is actually quite unusual for the United States to bring an indictment where they haven't obtained jurisdiction over the perpetrator. It certainly isn't just for Ukrainians, right? And I think on paper, it applies to anyone who has perpetrated a war crime as defined by the War Crimes Act.
When I was looking at that, I was thinking, whoa, whippy, is this kind of bonanza time for strategic litigators such as yourself, that you're all going to start piling into the courts?
Well, I don't know about that. I think that the federal statutes have always allowed us to bring cases in U.S. courts. And so, while the amendments to the War Crimes Act does give us another tool, it hasn't been the only one available to U.S. practitioners or to the U.S. Department of Justice when it comes to criminal prosecutions. I also think that the War Crimes Act, while our read of it is that it's applicable to anybody who has perpetrated a war crime, I think in application that may be an entirely different matter. So as I mentioned, there's the case that the Department of Justice has brought against Russian soldiers in Ukraine, but at the same time, we see other cases that have been pending for quite some time involving potential war crimes, such as the investigation investigation into the killing of Shireen Abu Akleh that has been pending for close to 2 years now at this point, and that we've seen no resolution on. And so I think that while these laws give us more ability as a technical matter to bring these cases and to see these cases brought by the Department of Justice, there remains a real question about sort of where's the political will in investigating the full range of crimes.
Just for those who haven't followed that particular case, that's of a Palestinian journalist, and it's a couple of years old already, who was killed allegedly by Israeli forces. And I think she also had US citizenship, which is assumed why you have been able to already pursue the case up until now. Let's just look a little bit at some of the broader context for CJA's work. I mean, I was trying to work out how many cases you're involved in every year, and I suppose they just go on for a long time. Do you have a number, if people ask you?
They do go on for a long time. At any given time, I think we are working on roughly a dozen different country situations, either in active litigation that we've brought, or domestic prosecutions, or universal jurisdiction cases that we're supporting through evidence and victim representation, or cases that are under investigation.
One of the cases that I was reading about, which intrigued me, partly because it's about a journalist and partly because it's got the connection to the Netherlands, was about something that happened way back in 1982, which is, I don't think an awful lot of our podcast listeners were actually alive then. Back then in El Salvador, a group of journalists were ambushed and killed by members of the military, and you've brought a case against a Colonel Mario Reyes Mena for his alleged role in the killing of one of the journalists, Jan Kauper. So why don't you talk us through that case? We're talking El Salvador and the Netherlands, so why the US? How's it all going? Where in the US? Give us the spiel. What is this case?
This case is very exciting. As you mentioned, we filed it very recently, but it's been a long time in the making. This case involved a crime that happened during the Salvadorian Civil War, and it's one of the most iconic crimes that took place during that Civil War. It was, as you mentioned, the killing of 4 Dutch journalists who were there to report on the human cost of the conflict. And as they were setting out to report, they were ambushed and killed by the Salvadorian military. And this was something that the UN Truth Commission that was set up after the end of the Civil War had established, that this was a deliberate attack on these journalists by the Salvadorian military. What I think is incredibly important about this case is that it was a time when truthful reporting about what was happening in the conflict was so important, not only to get the word out and so that people understood what was happening, but it was important to allow those in the international community who may be supporting El Salvador to understand actually what was happening in the country. And so that sort of independent reporting was critical for bringing about an eventual peace. And so the silencing of those journalists had a ripple effect on independent reporting in El Salvador. So why are we bringing this case 40 years after the fact in the United States? After the close of the Civil War and after the Truth Commission made its findings, the Salvadorian government enacted an amnesty law, which protected it itself, the Salvadoran military and the guerrillas from prosecution for any international crimes they might have committed during the war. And, years of cover-up and amnesty really resulted in a long delay in justice. The amnesty law was eventually repealed, found unconstitutional actually by Salvador's own courts. However, by that time, the perpetrators had disappeared and it was unclear whether this investigation would ever reopen. The families never lost hope and kept pressing for prosecution and investigation in El Salvador, in the Netherlands. And it wasn't until very recently it was discovered that the commander who was in charge of the base, where that foot patrol that ambushed and killed the four Dutch journalists set out from, was based in the United States. This was actually discovered by Dutch journalists who had been tracking this case and discovered him in the U.S. And so after that, we got in touch with Salvadorian civil society to see what their interest was in seeing a case brought in the United States against this perpetrator. And we start every case like that because we recognize that these cases that happen in the United States need to have some impact beyond what happens in our courtrooms. They need to be able to propel a domestic accountability movement. And so we think about the cases that we bring as a form of transnational litigation that really serves to support domestic accountability in the countries where these atrocities occurred, and to support human rights defenders who are doing that work, who have been doing that work, to allow them to advance their cause domestically. And so that's how this case started for us, that we built these networks with Salvadorian civil society, that we looked for ways in which our case could be brought so that it would support domestic strategy. And as we investigated and developed this case, we learned that there was evidence in the United States that would help an eventual prosecution in El Salvador. And it just so happened at the same time, Salvadorian prosecutors reopened this case and issued indictments and are now moving forward with a case of their own. The problem is that our defendant, Reyes Mena, is in the United States. He has no interest in returning home to El Salvador to stand charges. And so while two of his co-accused are facing charges in El Salvador, there is still an indictment out for Reyes Mena, but it's unclear whether he's ever going to go home. So because of that, we brought this case in the United States in order to see accountability for him while he remains on our soil.
And I understand this case is under the Torture Victim Protection Act, which I see that you've used before in other cases as well. Any guesses how long this might take? No, you're just shaking your head there.
Our cases range in how long they take. Some of our cases have concluded in about 2 or 3 years. Some cases, it takes over a decade for them to conclude. It depends on in significant part on just how quickly the courts operate. It depends in significant part about what sort of defense and legal issues are brought up. It's really like any other piece of litigation. Because our cases are civil, they are not subject to the same sort of speedy trial rules that criminal prosecutions are. So our cases may take some time, but the defendant here is quite elderly. We think it's important for the families who've been waiting for over 4 decades to see justice to see this go to trial. And so our aim is to move expeditiously on this case.
The other thing I think I've noted is quite a lot of cases around Syria and what happened there, because there's been so little justice for what happened during the conflict inside Syria. So maybe you could talk through a little bit about Syria or maybe some of the consortia, how you approach your work.
We see the cases that we bring, especially since we bring civil cases, as a way to advance accountability for movements. And why do I say this? For a couple of reasons. One, as I've mentioned, because these cases are transnational. A verdict in a U.S. court may have only limited impact on either the country where the crimes took place or for the impacted community that may be outside the United States. And so part of our strategy is to think about how do we make transnational litigation matter? And the only way we know of how to make that matter is to work very closely with the impacted community and with domestic accountability movements to understand their strategies for advancing their work and to see how we can fit, our case within that broader strategy. One of the beauties of a civil case is that we represent the plaintiffs. And in a very critical way, the plaintiffs are in the driver's seat here. With a criminal prosecution, the case is given over to prosecutors. Prosecutors decide what that case looks like. They decide what charges to bring. They decide what witnesses to call. They decide on the shape and the narrative of the case. Whereas in a civil case, the plaintiffs are the ones who get a say in what claims are brought, how you frame the violation, what stories are important to tell. And in that way, we are able to consult broadly with civil society who's working on this issue to build cases that are much bigger than just the case itself. So what do I mean by this? You were mentioning Syria. We have a case right now that we're litigating under the Foreign Sovereign Immunities Act, which allows us to bring civil claims against state sponsors of terror, of which Syria is one, for certain violations of international law. And in this case, we represent one individual who was tortured in a prison in Syria. But because we envision these cases as being much broader than the case involving just the plaintiff, we are marshaling evidence from dozens of witnesses who have different experiences than our client in order to tell a much broader story of what is happening in Syrian prisons, of the impact that torture and disappearances in Syrian prisons have on families and in communities, on the gendered aspect of detention and disappearances in Syrian prisons, and so on and so forth. So our ability to, in some ways, control the case allows us to bring a much bigger case, and a case that hopefully reflects the needs of the impacted community, in a much more profound way. And we do this through intense consultation. And so as we are developing a case and as we are building out a litigation strategy, as we are thinking about the kind of evidence we want to put on, we are in conversation and consultation with civil society, survivor-led organizations, families of the disappeared, in developing what we think would be a case that is responsive to their advocacy goals and to their justice needs.
I'm chatting to you just at the end of October, just before the presidential elections, and I think, like much of the rest of the world, watching to see, the debates and what the issues are for Americans to make their choices, and it does feel like accountability for war crimes, for crimes against humanity, for torture. I mean, it's just not on the agenda at all. Do you see any interest in that in terms of down ballot amongst the different people running for different positions?
That's an interesting question. I think in terms of what is in the discourse around the election, this is, international justice is not high on the list of talking points. But for international justice practitioners like us, it's always lurking in the background, right? Our Congress is right now potentially trying to sanction the ICC again. We obviously are concerned. We're concerned about the US's role with respect to the international community, its role with respect to the ICC. For us, we practice in the US courts. We use international human rights law in US courts to litigate our cases. And our ability to do that really depends on the makeup of our judiciary. As international practitioners and working in US courts, we use international human rights law all the time. And one of the things that we're always concerned about is the rule of law in our own country. One of the key things that presidents can do is nominate federal judges for appointment. One of the things that I think we don't pay enough attention to is really sort of the makeup of our courts and that impact that has on our ability to domesticate international human rights law in U.S. courts, which is important for the United States itself and our own rule of law, but also important when we think about the role of domestic courts in ensuring that international law is respected.
How do you see how the landscape is in the US for you to do your work? Because it looks to me from the outside like you've got quite a lot of interesting bits and pieces of the patchwork that you can make use of.
Yeah, I mean, I think one of the things that we've observed across administrations, regardless of which party is in political power, is that at some core level, the United States remains committed to human rights. And I think, what you point out is this ability that we've had to bring cases in the US stems a lot from the fact that our judiciary and our juries think that there is a role for US courts to play in ensuring that human rights is respected around the world, and where perpetrators are found in the United States, that they're held accountable where they are found. And so that gives me hope, regardless of the outcome of the election. It also reminds us that whoever is in power and whatever new administration comes in, is that they have a duty and an obligation to ensure that rule of law remains robust in the United States, that our courts remain open for business when survivors of human rights abuses come seeking remedy and redress, and that we continue to play an important role on the international stage when it comes to international justice. And that means, first and foremost, that we do not continue to attack and demonize the International Criminal Court as we have been.
We always finish off the podcast with a couple of questions, and one is whether you have any particular court cases that you are always referring to when you're talking about your work, or something that maybe inspired you to go into this work in the first case. I mean, as a lawyer, people often have a favorite court case.
Oh my goodness. I do not have a favorite court case. I have a most perhaps unfavorite court case. And that is the reason perhaps why I practice law the way I do. So my most unfavorite court case is a case called Korematsu. And it's a case from the United States Supreme Court. And it involved the incarceration of Americans of Japanese descent during the Second World War. And in that case, the United States Supreme Court found it absolutely constitutional for that to happen. And it serves as a reminder of the limitations of what law can do and the violence and injustice that law can wreak. And that, I think, is why it's perhaps one of the most important cases for me, because it is a reminder of what we as lawyers can achieve and what we can't. And so that's why I always think about the work that we do as being part of movements, as the kind of work that we do at CJA as being movement lawyers for an international justice movement. Because what eventually got Korematsu overturned was a lawyer, but a lawyer working in community and as part of a larger movement that denounced the injustices of this decision. So that would be my most unfavorite case, but a case I go back to over and over again.
And I know that you've been traveling a lot lately, so I don't know if you've had a chance to catch up on your Netflix or any other feeds, or whether you have a book that you've been carrying around with you. Do you have anything you'd like to recommend to our audience for reading, watching, listening to, either within the field or something that you use to get away?
Oh dear. Well, so one of the books that we just had our legal fellows leave us, and at the end of their fellowship, one of the things that we do is give them a book. And one of my staff attorneys had asked me, what book should we give them? And the one book that I recommended was Human Acts by Han Kang, who recently won the Nobel Prize for literature. And it's maybe not her most famous book, but it is a book that is beautiful and also a book that is fitting within our field. It's about the Gwangju massacre. It's about intergenerational trauma. It's about what justice and accountability means to individuals. And so I don't think it's a book that you would read to get away, but it is a beautiful book and I would recommend it.
Great. Thank you very much for your time.
Thank you.
This was Asymmetrical Haircuts, your international justice podcast, created and presented by Janet Anderson and Stephanie Vandenberg. This episode was created in partnership with justiceinfo.net, an independent site covering justice efforts for mass violence, and with the Hague Humanity Hub. Music is by autonautics.com. You can find show notes and everything about the podcast on asymmetricalhaircuts.com. This show is available on every major podcast service, so please subscribe, give us a rating, and spread the word.